More and more criminal cases are coming to light worldwide in which innocent citizens are exonerated of crimes that they never even committed, and often after years of litigation. And such miscarriage of justice, of course, have very serious consequences for the innocent individuals and for their families on a longer term than you might expect. And we will hear more about this from Amanda and Raffaele later on today. But research on US wrongful convictions also have shown that the majority of actual offenders committed crimes, including murders, during the time that an innocent person was convicted. But compared to the exhaustive North American databases, such as the National Registry of Exonerations and the Canadian Registry that was launched very recently, as well as the UK Miscarriage of Justice Registry that includes the British Post Office scandal, the extent of the problem of wrongful convictions in European countries was still very much unknown and also very difficult to assess. And with EUREX, we aim to survey European exonerations to gather a comprehensive overview of these cases, their causes and risk factors, just to get a reliable understanding of really how often and for what reasons wrongful convictions occur in European countries and what individual and societal consequences arise. And from this, so from now on, we can also initiate more targeted research into these underlying factors and raise awareness for remedies in European policy, such as conviction integrity units. It varies greatly between countries what counts as an exoneration or even what counts as a conviction, and also between these registries that I've just spoken about. But for EUREX, we include exoneration cases that are definite, so someone is convicted without any further legal pathways to pursue in a final judgment, and then is officially cleared in a post-conviction re-examination after, for example, new evidence of innocence becomes available. And we include cases where the convicted person was declared factually innocent by an authorized government official or agency, was acquitted of all charges, received a dismissal, or even received a complete pardon from a competent authority. And we are taking cases from 1970 onwards, since from that time there have been no substantial changes in the legal system, and most cases are well documented from that time on. But the cases that we have identified, so those cases of post-conviction review that led to exoneration, are not representative of all wrongful convictions as a whole. So, for example, we do not include successful appeals or cassation procedures, nor do we include innocents that were found earlier in the legal process, for example, due to an expert witness report. So, of course, this definition, this legal definition in Europe is debatable. And this also means that not all innocents, irrespective of how long they spent in prison for a crime that they didn't commit, are considered official exonerations by law, including, and this may surprise you, our guest speakers, Amanda Knox and Raffaele Sollecito, who will be speaking here today. And there are more of these cases where irrefutable evidence of innocence was found before seeking this post-conviction relief, and hence these individuals are not considered exonerated. And we also have a few cases from Spain, for example. And from the two Knoop's Innocence Project's lawyers, we will hear more about the pathway towards an exoneration today, which may be a very long and bumpy road. But first, let me introduce the team to you. So when I talk about us, I mean Jenny Schell-Loigers from University College Maastricht in the Netherlands, Teresa Schneider, affiliated with the Philips University Marburg in Germany, and the Lucerne University of Applied Sciences and Arts in Switzerland. And my name is Linda Geef, and I'm from Leiden University in the Netherlands. But we couldn't have done this without the help of our funders and the involvement of research assistants, website builders, animators, graphic designers, and colleagues from all over Europe for sending us their cases. So thank you to the funders, and also a very big thank you to all collaborators for sending their cases of their countries. And also to you, our audience today, for sending us cases in the future. So we're counting on you as well. So it's already a very long list of people to thank, but we are very grateful to all of you individually. So today we finally present the very first findings of the European Registry of Exonerations, and we are proud to tell you that we have managed to get exonerations from 17 different countries already. And while it is very good to look at these cases together to find common factors, I also want to highlight today that these all represent individuals who served time in prison or forensic facilities for crimes that they didn't commit. So although we will talk a lot about numbers today, we're also talking about lives, right? So these cases all have come to light in the past 50 years, but again, they're probably not all wrongful convictions. Also, there may be more official exonerations in these countries that we are just not aware of yet. And there are a few countries, for example, Belgium, where there are no known exonerations, which could mean that their justice system is perfect. It could also mean that the legal threshold for retrial may be too high. The cases that we have, they represent two different types of exoneration. So first we have exonerations in which actually no crime occurred. So for example, in the Dutch case of Lucia de Berg, she was a nurse in a hospital and she was accused of killing multiple patients in her care. But later they turned out to be natural deaths. So actually no crime occurred. And the second category is cases in which an innocent citizen was convicted of a crime that someone else committed. They also include both jury-based trials, for example, in Spain, judge-only trials, as we have, for example, in the Netherlands, and there are even mixed trials, for example, in Germany. And in total, we have found 115 exonerations, and these are 113 unique individuals. So we have 2 people who were convicted and exonerated for separate crimes and therefore appear in our registry twice. But if you were convicted and exonerated of killing, for example, 2 people at the same time in the same instance, then you would only appear once. And these exonerations represent 103 different criminal cases, because sometimes 2 to 5 people were convicted and exonerated for the same crime. So for example, in Iceland, but also in Germany and the Netherlands, there are some cases where more than 2 people were convicted of one crime. In total, these people spent 812 years in prison, with an average of 7 years per person. The original convictions range from 1970 to 2017, with the first exoneration taking place in 1981. And this wasn't the person who was first convicted in 1970, because he was only exonerated in 1994. So as I said before, there's a positive trend in reversing wrongful convictions, and we see the majority of exonerations taking place from 2010 onwards. For example, one of the cases that we have included is Holger Gensmer from Germany. He was 28 years old at the time, and he was convicted of killing a 6-year-old girl in Germany in March of '71. And although he had an alibi, after several lengthy interrogations, he confessed to the murder. And he would have spent his entire life in prison if not for his lawyer, who rediscovered the evidence of his alibi. And after 16 years in prison, at age 45, he was exonerated. He wasn't eligible for compensation, though, since it was argued that he contributed to the wrongful conviction himself by confessing falsely. A more recent case is the case of Viggo Christiansen. In May 2000, the bodies of 2 young girls were found in Baneheia, a recreational area in Norway. And the police arrested 2 friends, so Viggo Christiansen and his friend Jan Andersen. And Christiansen was 21 years old at the time, and he denied any involvement. However, his friend Andersen confessed to having acted as a lookout for him, and told police he was forced by Christiansen to kill one of the girls, and he said that Christiansen had killed the other girl. In June 2001, Christiansen was then convicted of 2 counts of premeditated murder and rape, and he was sentenced to 21 years in prison, and that's actually the maximum sentence in Norway. And the conviction was secured mostly based on Andersen's testimony, so his friend against Christiansen. And Andersen was convicted to 19 years in prison for 1 count of murder. Christiansen continued to maintain his innocence, and he appealed his conviction 6 times without any success, until in February 2021, the Norwegian Criminal Case Review Commission finally decided to reopen his case. And in December 2022, Christiansen was acquitted. And his former friend, Andersen, had killed the girls by himself, but falsely implicated Christiansen. And therefore, Christiansen received a monetary compensation. The cases that we have in our database mainly include serious crimes, so mostly murder or manslaughter or attempted murder manslaughter convictions, and sexual offense convictions. And these can also go hand in hand, right? So people can be convicted for more than one crime, for example, murder with a sexual offense, or also in different combinations, for example, with assault, arson, robbery, or burglary. In some countries, people can be officially exonerated for administrative infractions like traffic things, but we only include criminal offenses in our registry. So when we look at the root factors underlying these convictions, we see a pattern of 5 different contributing factors. And interestingly, these are the same factors that are consistently found in the other registries as well. So they seem to be quite universal. And we will code all exonerations in more detail in the future, but here are some general findings so far. And again, here, sometimes there's more than one factor involved in a single conviction, right? So in 29% of the cases, a false accusation or perjury contributed to the wrongful conviction. And these represent both unintentional and intentional allegations. So for example, an accusation of a victim based on a false memory, or as we have heard in the Christiansen case, someone intentionally pointing to an innocent suspect, for example, in return for a lower sentence. Other reasons may be for revenge or for attention. In most of our cases, a false confession contributed to the conviction. So innocent people implicating themselves and confessing to a crime that they never committed in the first place. And most of these fall into the so-called coerced false confession category, meaning that they were police-induced. So they represent innocent suspects who falsely confessed because of police pressure during the interrogation. And in scientific research, several risk factors have been acknowledged. For example, personal risk factors such as younger age or lower mental capacities. But we may not forget the external risk factors such as the length of the interrogation, or example, the presentation of false evidence. But I'm sure we will hear a bit more about this from Professor Solkassen afterwards. And one case from Germany really comes to mind talking about false confessions, where a man called Ulrich Kulacz was sentenced to life in prison in 2004 for the murder of a 9-year-old girl called Peggy. And Kulacz had a developmental disability, which was not taken into account during the interrogations. And he was questioned under severe pressure for over 40 times and ultimately confessed to killing the girl falsely, and he was imprisoned for 11 years. This third factor, official misconduct, most often occurs together with other factors in the registry, especially a lot with false accusations or perjury. So when an official party tampers with witness evidence, for example. And like I said, we're still coding these cases on a 60-page coding scheme. And in addition to the general information that you will find on our website later. And we actually think that more cases will be classified as official misconduct as we go along. But in general, this category includes perjury by official bodies, so police, prosecutors, forensic experts, lying about evidence or withholding exculpatory evidence that would suggest the exoneree's innocence, or lying to conceal evidence that may incriminate someone else, right? And we also coded the case of Giuseppe Giulotta, a false confession case, as official misconduct as well, since he was literally tortured in the interrogation room. This is an Italian case where Giulotta spent 22 years in prison for killing 2 police officers before being acquitted in 2012. And that's actually 36 years after the crime took place. And in the retrial, one of the carabinieri, so the police officers involved in the investigation, actually admitted that his confession was obtained through torture and intimidation. And the real perpetrator still has not been found to this day. The fourth factor is the use of false or misleading forensic evidence. And we code this when the forensic methods used were previously scientifically recognized and are now no longer considered reliable, as well as faulty or misleading expert or forensic evidence that led to an erroneous conclusion at any stage in the investigation. So for example, if we talk about mistakes in forensic testing, it would be when the exoneree has type A blood and therefore is believed to be the donor of the blood stain at the crime scene, which is also type A, when in a post-conviction relief, it is found out that the crime scene stain was actually blood type B, so there couldn't be a match, right? Or we code for overstated or misleading evidence. So for example, in this Dutch case of Lucia de Berg, the hospital nurse I told you about, where based on a statistic calculation, a scientist reported that the chance of Lucia being on shift during all deaths was 1 in 342 million, which would be very convincing if it were true, but it was a miscalculation. And here I would also like to highlight the case of Tomasz Komenda from Poland, who was convicted of murdering a 15-year-old girl. An expert said that the hair at the crime scene and the bite mark of the victim on the victim belonged to Tomasz Komenda. And these methods were later considered to be unscientific. And after 18 years, Thomas was released and the real perpetrators were found. So finally, we have a large amount of cases falling into this category of flawed eyewitness identification procedures. And this mainly includes the erroneous recognition of the exoneree by witnesses. And while eyewitness memory can be very accurate, they do lead to false outcomes when we rely on witness accounts under non-pristine conditions. So these can be found in, for example, the distance to the perpetrator or the duration of the event, whether it was dark, or so-called other estimator variables, as well as, for example, the way in which lineups are conducted, instructions are given so that the perpetrator may or may not be in the lineup, and that we shouldn't ask for, are you sure, in a very leaning manner, for example. But false identifications can also occur independently of lineups, such as through a false recognition based on a police sketch, which we actually see quite often in the registry. And one case I want to highlight here is the case of Ahmed Tumouhi from Spain, and he was identified by several rape victims as the perpetrator, but then he was acquitted because his DNA didn't match. And the victims were actually very, very accurate, because if you look at the picture of the real perpetrator, he and Tumouhi actually almost look like twins. And as we have heard from these case examples, the numbers in our registry represent actual people who have spent many years in prison before they were acquitted in a retrial. And as we know from research, prison sentences are very stressful for most guilty convicted people and their relatives too. So imagine the psychological impact of being wrongfully convicted. And paradoxically, wrongfully convicted individuals are in a very unique situation because they're often released quickly with no community re-entry plan, and they do often not qualify for the same reintegration services as those released on probation or parole who were actually guilty. And the case of Horst Arnold from Germany shows that the reintegration into society as an exoneree can be very difficult. He was imprisoned for 5 years because a colleague had falsely accused him of rape. And after serving his entire prison sentence, he was then acquitted in a retrial in 2011. And despite his proven innocence, he was no longer able to find work as a teacher, and he lived on an unemployment benefit. And he fought for the appropriate compensation, but then died of a heart attack in 2012 before the settlement went through. So it doesn't really end when the sentence is served. I think that that's a message that I want you to take home. And research has found this significant impact on mental health, but also on challenges in finding housing and finding work. So that reintegration is often very difficult. And I think we will hear a bit more about that from Rafaela and Amanda today. And also public attitudes towards exonerees are often very similar to attitudes towards convicted offenders, whereas they should actually be similar to attitudes toward general citizens. But to end on a positive note, with EUREX, we want to make an impact on the approach to reviews in the European context and to understand and to prevent exonerations on a large scale.